police itself.
Welcome to the September 9th meeting of the Town of Mills River Planning Board. We'll bring this meeting to order by starting with the Pledge of Allegiance.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Do we have a motion to approve tonight's agenda?
Motion to approve the agenda.
Can we have a vote for those in favor of approving tonight's agenda?
Aye.
Aye.
Hearing any nays? No nays. Do we have a motion to approve the minutes of the August 5th meeting?
I did read them.
I will make a motion to approve the minutes from the prior
Thank
meeting,
you.
August 5th.
And I'll
Brian.
second.
Jenny? Can we vote on the motion to approve the August 5th meetings? All say in favor, say aye.
Aye.
Any nays? Okay, no no's. So let's go ahead and hear from staff. See what kind of staff updates we have tonight.
Great, thank you, everyone. A few updates for the board tonight. I know we sent an email out, but just wanted to remind everyone we have the UDO consultants coming into town and for the public as well. Wednesday, September 24th through Friday, September 26th. There will be a couple opportunities for public input during this time. For this group, particularly the UDO steering committee will be meeting between 6 and 8 p.m. on Wednesday, September 24th. Public's welcome to attend as well, but that's mainly for the committee to review work products from the consultant. We will have an office hours available for the public to schedule appointments either with staff or the consultant between 9 a.m. and noon on Thursday, September 25th. And then after that, we'll have a drop-in public forum the rest of the day from noon to 5:30, where staff and the consultants will basically have boards up and we'll be workshopping some of our potential new zoning districts, potentially first version of a concept new zoning map for the town, and other items regarding the annotated outline, which again is the bones of what the new unified development ordinance would look like. And then lastly, there's going to be another office hours block in case people weren't able to make that public forum. They can schedule time again with staff or the consultant, also 9 a.m. to noon, Friday, September 26th. Secondly, wanted to state that council appointed our new member to fill the vacant seat of former member Lonnie Oliver. Brad Burton was appointed by council last Thursday, so we welcome him to the board. He did have an existing conflict travel plans for this meeting, was unable to attend. Last update, I just wanted to let folks know that staff is in the final stages of approving the schoolhouse industrial project. This is the one we've been working on for maybe 2 or 3 years with developers. It's the 14 acres at the northeast corner of Schoolhouse and Banner Farm Road, about 222,000 square feet of warehousing and distribution space in 2 separate buildings. The plans we just found out today are compliant with all of our watershed and stormwater requirements, and that was the last hurdle the applicant was looking to overcome. So we expect to issue permits for that next week. And I would anticipate the developer to move relatively quickly to begin dirt work and site work in the fall before the construction season closes for the winter. But that's all I have for the board tonight. Happy to take questions.
Is the UDO meeting or any of them, will they have a virtual option?
These ones will not. The steering committee meeting specifically for members of this board or the Board of Adjustment, we are going to record that. And so we will send that recording link out to members who are not able to attend. So you could watch it at a later date. And then if you have comments or feedback, feel free to send that to staff and we can communicate that to the consultants. For the drop-in public forum, because that's going to be, people mingling in throughout the day, that won't be recorded. But again, the project website will be updated with all these materials, and hopefully next week, the project website will be updated specifically for this trip. But also after this trip occurs and after the public forum, there will be additional items like the consultants produce a couple pages of trip notes, kind of summarizing feedback and what happened during their visit. And those are usually posted a couple weeks after the visit takes place on the website. And again, that website for the public is imaginemillsriver.com.
And did you say the steering committee meeting is open to the public? I believe you
Is
said
the
that.
public meeting? I'm sorry, that was my mistake. That's
Okay.
not open to the
Okay.
public.
It is being recorded.
It's being recorded
It's not open
for
to the
steering
public.
committee
Okay.
members, yes. Again, that is basically a meeting between the steering committee members council has appointed, which consists of the planning board and board of adjustment seats. And that's reviewing detailed work products with the consultant, basically to inform the next steps in the process.
But we're still open to questions. Just don't move on quite yet.
Yeah. So I understand, you just said that you expect materials to be posted to the website sometime next week,
Ideally, yes.
ideally, and is there any particular document that the steering committee should look at in advance? Is there something that's going to be the kind of discussion document?
So the consultant, should be preparing a presentation for the steering committee, and we have asked that to be sent to staff in advance so it can be distributed. Now, the annotated outline itself is, again, the bones, kind of the outline of the full unified development ordinance, but we're talking over 100 pages. So I don't know if that's wise for the steering committee to read through all of it, but you may want to take a skim through some specific sections. The most important thing I would think is, and I don't know when this will be released, but is the consultants are also working on potential new zoning districts and a new zoning map. And that will be something that's workshopped both with the public and the public forum and with the committee members. And so that will be sent out as well.
Is that this meeting, the zoning, or is that a future meeting?
The first version or the first concepts that are proposed by the consultants will be workshopped this September 25th and 26th meetings.
Okay.
Or sorry, 24th, 25th, 26th. Oh, out.
I'm guessing there's not anything here, but is there anything the public should need to know about Ohalo? Anything there?
I'm not aware of any
Okay.
development taking place there, but as you know, agricultural uses are exempt, so it's possible something's occurring and we've not even.
More specifically about their future here in Mills River.
I'm not aware of anything regarding that.
Okay. Then I won't bring anything up. The other question is, I was at Ingles the other day and dude, that parking lot is crazy. Is there anything the town can actually do about what used to be discussed about slowing them down? Specifically the 2 exits of the store. I know we used to have a conversation, but I think it was a voluntary conversation on their part. Can we?
And you're talking interior to the lot or the access points to the public roads?
Sorry, the interior of the lot with the pedestrian access
Mhm.
from the 2 doors to the parking lot. It's just.
There were previous conversations about it. The town doesn't have zoning authority to enforce anything because there was no development application. Now, they're doing the interior remodel, which I think is still ongoing.
Yeah.
And so they were making some exterior improvements, but nothing that would trigger a zoning permit. So new striping of the parking lot. So we just verified, the parking stalls would still be the correct size, the lane widths, et cetera. Now, we did express concerns because we had also heard concerns, oh gosh, 2 years ago, maybe from a council member about potential conflict points with pedestrians crossing there and also that outdoor seating area. There's not a whole lot of room to walk. I believe there's now like a brick wall.
Outside of the posts?
Yeah, outside of that outdoor seating area, so you have to kind of go
Yeah.
in it. But the idea, what staff communicated to the engineers coordinating the project is that there is a concern regarding safety there, both traffic and pedestrian. And we encourage them to add stop signs, add pedestrian yield signs, and also increase any signage stamped into the ground, which I think they have painted new stop.
Right, I thought there was
Signage.
discussion of like rumble strips or raised surface.
Correct. And
The
I
one
don't,
point.
I don't know if they're going forward
Right.
with that.
So the reason I bring it up is one, they keep expanding. I mean, that place used to just, now we have the dentist, we have Papa John's, we have, what is the medical place at the end? The traffic is getting more and more. Is there anything we can put in there to trigger at some point? Is one of my questions to trigger, but two, what's going on with the same issues that we're gonna have at Publix?
Well, so
Because
going
we
to,
all know what happened with Ingalls and there
Yeah.
was some nodding and handshaking there. Publix is not an arrangement with anybody. This is being done by the book. Is there something there?
so the traffic study ordinance that's been in place a couple of years would capture that. So if there's any increase or expansion of development, and if that vehicle trip threshold is met, they'd have to do a TIA, a traffic impact analysis. In my time here, the Ingalls Shopping Center has not applied for a permit for any permanent expansion. So while that ordinance has been in effect, it hasn't captured anything with the Ingalls Shopping Center. At one point, they were proposing a car wash or Zips on that out parcel, but that never came to fruition.
Okay,
It's
so that's my
vacant.
next question, because they have out parcels, and right now Ingalls only out parcel is the gas pumps. But Publix has out parcels, no?
So Ingalls is actually all one parcel, but they have one green area of land left to develop.
Right.
And it's still allowed per the old county's watershed permit. And that was where the Zips was gonna go.
Right.
Again, if you're looking at it from
The
the
left.
road, the
Right.
left side,
Right.
the southernmost part. Going to your second question about the Publix did go through the traffic study.
I'm talking about
process.
interior, just to clarify my question.
Okay,
Interior,
interior traffic. control.
interior traffic, just so that we're not having a,
So staff, because it was a similar conversation with Ingalls, staff made the same point, that there were concerns and we just wanted to make sure there was adequate signage and awareness of pedestrians there. And I'd have to look at the plans in detail, but I believe they were gonna install like pedestrian crossing warning signs, the bright yellow ones. There will be crosswalks going from the parking
Sure.
lot to the store. And then the out parcels right now, there's nothing proposed for development of those. But if and when something is built, that's when we would have them submit trip generation numbers, see if it triggers the TIA ordinance, because it would
Okay.
be above and beyond what's already there, and there would be an analysis.
okay. Okay. Thank you.
Does anyone else have questions for staff? this evening? Oh, please, yeah.
I have a comment with that point. I just want to say I have to leave at 7:15. And I understand, if I'm not mistaken, that any vote taken will be counted as a yes vote. Right? I understand that.
Good to get that clarified. Okay, well, nothing else? Okay, so, any board comments or updates? No? Okay, any public comment?
No.
Nothing? Good. Okay, we don't have any old business, so I guess we're on to the new business of talking about the floodplain hazard prevention ordinance review and recommendation.
Before I,
You know, this TV's not.
I was just gonna say, before I go into that, if we could take a brief break while I fix this TV so y'all can see.
Perfect. We can turn around if we need to. I don't know what that means. Okay. Okay.
21st century hieroglyphics.
I like smiley faces.
Exactly. I thought it was actually part of the floodplain ordinance, but apparently not.
Flip.
Always did like floating.
Yeah. Excellent. Thank you.
Operating a couple screens here. There we go. Okay. So thank you, everyone. So as you may know, council spent the better part of the spring into the summer discussing a possible floodplain ordinance for Mills River. And in these discussions, basically council's made a couple of decisions, and that's resulted in the draft ordinance that's before you tonight. So a couple of those decisions that crafted what you'll see in your packet is that council made a specific choice not to have a floodplain ordinance that meets FEMA or National Flood Insurance Program NFIP criteria. They also chose they don't want to adopt an ordinance until we have further clarification from the attorney on the impacts of down zoning, because again, per that state law, any local government can't down zone or restrict the use of land per that new state law. There was specific consensus from council about limiting fill and land uses in special flood hazard areas, so only allowing specific types of development activity. And then in a bunch of subsequent meetings in May and June, council and staff really narrowed down on the specific regulatory provisions and uses allowed in the ordinance. And so if the planning board's okay, I'm going to go through a PowerPoint presentation and we'll kind of summarize all the high points of the ordinance. And then I'm happy to take questions or go through the ordinance line by line. One second. This is why I need Kevin. Okay. Okay. So we kind of covered this already. The specific direction council gave staff in terms of drafting this ordinance. We probably talked about this here previously, but the town only has the authority through this type of ordinance to regulate up to the 100-year floodplain. So you can see in this graphic, the floodplain encompasses a couple different areas. The flood fringe is usually what's called the 100-year floodplain only. Within that 100-year floodplain is also the floodway, the area where the river or stream regularly overflows and inundates land during a flood event. And then you can see here you have and also the base flood elevation, BFE. That's a term you'll see in this ordinance. That's basically the calculate the wall rises to in a 100-year flood event. So this is just a comparison of what a FEMA NFIP compliant ordinance would provide to the community, or what would be included in the ordinance, versus what Mills River is doing in this draft ordinance before you. So in a normal FEMA floodplain ordinance, there would be regulation of agricultural development. That is very limited in this ordinance, but there are some provisions included. You can see a no-rise engineering study for any type of development. That's included in the ordinance as well, but again, is limited to where it's applied. One thing we did not get into was the permitting of residential or non-residential structures in the single special flood hazard area, elevation of structures, floodproofing of structures, and then provisions regarding substantial damage or substantial improvement, which basically says if you improve a structure beyond a certain extent, or if it's damaged beyond a certain extent, it either can't be rebuilt or has to be rebuilt to higher standards per the ordinance. Now, permits and variances are in the ordinance in some type of capacity, and then we do have the full section on enforcement and complaints. So this ordinance is a bit unique because of the state downzoning prohibition. Again, the town's in a situation where we're not going to be adopting this as a new land use regulation. So technically, because this is not a traditional zoning text amendment to our zoning code, it actually doesn't have to go before the planning board. But because this is such an important topic, staff felt it was wise to basically bring it before the board, provide other opportunities for public comment, and still go through the normal text amendment process. But I did want to highlight, because this is an ordinance adopted under the municipal police power to protect the public health, safety, and welfare, this would basically be an ordinance similar to like our nuisance code. So again, this is a hazard ordinance meant to protect the community. So again, here's the specific statutes that grant a municipality authority to have a flood hazard prevention ordinance. But this statute says that ordinance has to meet FEMA criteria. So we did not rely on that statutory authority. This specific reference statute says any responsible local government can have regulations for floodplain management in the 100-year floodplain, and says nothing about it meeting FEMA or federal minimum requirements. So this, and then the specific articles, I believe it's Article 8 of 160A of the general statutes, which contains all the municipal police power sections. Those are the sections we're relying on for the authority to potentially adopt this ordinance. So again, going into down zoning, I kind of just covered this, but again, we're focusing on adopting this ordinance as a hazard prevention ordinance, again, through the police powers of the town to protect the public health, safety, and welfare. This is not a land management ordinance. This is not a zoning ordinance. We're not creating a floodplain overlay district. That's what you would traditionally see, is floodplain overlay zoning districts that then have land regulations attached to them. This is basically a hazard prevention ordinance that states if you're in this high hazard area for floods, the special flood hazard area or 100-year floodplain or floodway, there are these specific limitations on what you can do, again, to protect the public health, safety, and welfare. So let's go through some of the sections, just highlighting the general provisions of what's before you here. Let me catch up on my computer. So specifically, Article 3 has the actual listed prohibited and allowed development types. And again, this was workshopped through multiple sessions with town council, and this is what they've chosen to basically allow in this ordinance. So as it's written currently, the every type of development is prohibited except the following: a residential accessory structure, so like a shed, with no dwellings, no utilities in the structure, a bona fide farm or agricultural land use or structure, and you'll see later, there's a provision that says that that has to be outside of the floodway. The application for a functionally dependent facility, which means a facility or land use that must be by water to function. Traditionally, this would be like a port or a marina or docks, but it could include something like a tubing operation. That would be one type of development that's allowed. The fourth one is any governmental or public utility use in the furtherance of an essential public service. So again, water, sewer infrastructure. If the town were to develop on the property next door, we would be allowed to do so in the floodplain because of that public focus. The other allowed type of development is for stream restoration, natural lands restoration, floodplain restoration, et cetera, but something that's going to improve the beneficial functions of the floodplain and the streams or rivers around it. And lastly, we do know, especially in the southern part of town, there are homes with driveways that cross through Boylston Creek, and there is a floodplain there, where the home or dwelling may be outside of the floodplain. And so we wanted to make sure there was at least an avenue that if folks are building homes, they can put a road through a floodplain to access their home. And that is what this sixth final allowed type of development is, for a private road through a special flood hazard area to access a residence outside the flood zone. And then it specifically states all other types of development are prohibited. Article 4 goes into the detail of the floodplain development permit, and that permits would be required for development. Again, so staff can make sure we're controlling hazards, for those potential applicants. This really is just an extra to that section that says one thing we're requiring with any floodplain permit is a site plan prepared by a professional. Because if you get into placing fill on a property, we need a professional who can, verify with their stamp and seal that this is the actual elevation of the land, or this is the actual elevation of the structure or location, so that site plan can be held accountable. We don't want to base floodplain permits on something drawn on a piece of paper in the office, because in this instance, and especially since we're trying to prevent hazards to health, safety, and welfare, we want to make sure that site plan is as accurate as possible. So this is goes into the floodplain permit exemptions. So currently the only exemption from floodplain permits is for bona fide farm and agricultural structures, but they must be located outside of the floodway or non-encroachment area. And as I get through, there are a couple other types of ag development, specifically chemical or petroleum tanks, that do have specific standards. But this would be for, a pole barn, something to store equipment in. So if a bona fide farm wanted to build that, there would be no permit required from staff, but basically we would, make sure that structure is located out of the floodway, because that's the area regularly inundated by floodwaters. So fill variances, I may cover this in another slide, but currently the way the ordinance is written, it allows an applicant to fill 5% of the floodplain area on their property up to the base flood elevation. And only for those types of development, those 6 development types we went through previously. So if you're doing a sewer pump station, you're a government use, you can, through the floodplain permit process, apply to put fill in for 5% of the property up to the base flood elevation. Now, you can get a variance for that, because let's say a sewer pump station from Buncombe Sewer wants to be above the base flood elevation to protect their infrastructure, and the pump station serving Mills River, they could apply for a variance. And the maximum extent for a fill variance is 15% of the special flood hazard area up to 2 feet above the base flood elevation. So again, 2 feet above the flood waters, from the regular 100-year flood per hydrologic models and studies. I'll say before going on to this slide that the ordinance has a lot of requirements for a variance to be granted. If you look through that section on variances, you have to prove beyond a reasonable doubt that fill is absolutely necessary for the development. You have to do the no-rise engineering certification stating that fill and development on the property will not cause an increase or a rise in floodwaters. So there's a lot of additional requirements for a variance or a flood variance or fill variance to be issued, and that role would be filled by the Board of Adjustment, who typically deals with variances in the quasi-judicial proceedings. Going into this slide, this is the general standards for fill. I, again, talked about this previously, but just wanted to give you the base standard for fill before going into that variance provision. So again, the general standard for fill is 5% of the special flood hazard area and up to the base flood elevation. Now, how does that affect bona fide farm uses and agricultural uses? So right now, the way it's written, agricultural land maintenance activities are not considered fill. So if you're changing out a culvert pipe, if you're running over your field and turning over the dirt, as long as there's no change in the elevation of the land and no change in the topography, that will be allowed without a floodplain permit. But once fill is imported into the site and the elevation or topography of the land changes, that's considered fill for an agricultural use, which is prohibited. Again, I'm going out of order a bit here, but 5% is the total amount of fill and would require a floodplain permit. This third bullet is an important one. Anytime there is a fill activity of any type, whether it's 5% of the special flood hazard area through a permit approved by staff, or whether it's a fill variance, the applicant would have to complete and execute a non-conversion agreement. And this is something you see in the FEMA federal compliant floodplain ordinances. Basically, it's an agreement, legal agreement drafted by an attorney that the owners would sign and file with the Register of Deeds and would run with the land, basically be tied to that property in perpetuity. And it would say, based on this permit issued and the conditions of that permit, this amount of fill is allowed on the property. And that would, again, non-conversion agreement, that could not be changed or converted in the future because that property has filled the maximum extent of land available. Now, there is the possibility that a future buyer, could come in and ask for a fill variance, but then they would have to prove, all those special requirements and circumstances beyond a reasonable doubt that fill is absolutely necessary for the development. Again, only for a fill variance above the 5% base fill allowance. And then again, there's multiple sections in the ordinance where we call out the prohibited development types, and we call it out again a couple times that fill is absolutely prohibited for any type of non-residential use, any type of non-agricultural development, any residential dwelling, whether it's single family or multifamily, and any elevation of land for future development purposes is expressly prohibited. So that's the quick overview of all the regulations. I'm happy to go through the ordinance in more detail. Again, just to give you an idea of where we are in the process, council's conducted multiple reviews. The last time we met with them, they were happy moving forward with this draft ordinance, which is before you tonight. Going forward, we'll move forward with advertisements, and there is a public hearing with council scheduled for adoption on October 2nd. And then again, we're mindful that we also have a floodplain development moratorium in place, which expires October 8th. the whole point of that moratorium was to give staff time to draft this ordinance and coordinate with council. And so that's what we've done, and we intend to meet that deadline.
Thank you.
So that's the end of the presentation. Yeah, I'm happy to take questions. I do also have responses to Mr. Burton's comments that he emailed out as well, but I'll throw it back to the board for now.
Okay. Anybody want to flag or have any questions for Michael or anything else you want to look at in particular?
I have one. So if the floodplain, the 100-year floodplain is updated and it's increased or decreased in certain areas due to whatever, will the town be notifying the impacted residents?
Not per this ordinance.
Okay.
Now, I will say, in the guise of hazard prevention, we do plan to have like a page on the website with some educational tools for the public. So the state of North Carolina has some amazing flood educational tools where you can literally put in your address and see the hazards present to you. And so that would be something we would push out with the launch of this ordinance. So while there wouldn't be direct communication, there is a public push for education that staff will make.
So, so my concern is, say, I don't know, there was development upstream and it pushed more water towards me. And then all of a sudden I'm in the 100-year floodplain, but I don't know it till a 100-year flood hits. What would you tell me to do before that? Check every year? How often is it updated?
10+ years. So I mean, right now, based on our state partners with emergency management, it just so happened to coincide with Helene, there is a remapping of floodplains occurring now. So we would hope to have, a look at those maps, and I'm talking off the cuff here, but I believe it was early next year.
Okay.
Now,
Prior was 07. They don't do it, I believe.
correct, yeah.
They don't do it as often as you want them to.
Yeah, I think the last, correct, I think it was 08 or 07. And then the original floodplain maps for the county, which were very rudimentary, I think go back to the early 80s. But since the early 80s, since they were first mapped, there's only been 2 other updates. The most recent 07 or 08.
But to your point, it's what happens downstream that impacts us more. And we're upstream from pretty much everything. The headwaters are, a county away.
Exactly.
So Asheville and then, Tennessee. So that development affects us. Ours will change drastically, I think, in 20 years, 30 years.
Well, what you see in the river up here is different than what I see in the river up north, on the north end.
Upstream.
Well, technically it's downstream
Yeah,
because French Broad runs north.
Right.
So, there could be sizable development, in an area that I may know about, but not be see any effects of it till the next flood.
A few things I'll say. So one, large non-residential or residential developments aren't going to happen if
Yeah.
this ordinance is adopted.
Yeah.
So hopefully that addresses part of the problem. 2, both this ordinance and all the other standard FEMA compliant flood damage prevention ordinances that I looked at all have a disclaimer stating that the 100-year floodplain is just a guide.
Yeah.
As we saw during Helene, there were plenty of areas that flooded outside of floodplains.
Yeah.
And so it states somewhere in here that, this is our best effort to educate the community and reduce hazards, but it cannot be relied on for every storm event.
And the elevation survey uses more than just FEMA maps.
Say that again.
Your elevation survey, that's not what you called it. I'm sorry, that's what I call it. The
Oh, the no rise certification.
no rise certification, part of that is an elevation survey.
Yeah, so if an applicant were to place fill on a property for one of those 6 allowed development types, and if fill's allowed, and if they had to do the no rise certification, they have to hire an engineer to look at all the hydrologic data from past floods from the 100-year flood, and basically literally create a model that shows what they're putting there won't create a rise in floodwaters downstream.
Was it a federal statute that doesn't allow us to have any say in the 500 year? Was that a state?
State.
Was state? Okay.
It basically lays out in that specific statute I referenced earlier that the regulatory authority is only within the 100-year flood.
Special flood.
Now, and again, don't quote me on this, but I believe municipalities before the downzoning prohibition could potentially regulate in 500-year floodplain areas.
It's not under the police act or the police municipal
Not-
police
not through
authority.
these
It was a
statutes.
zoning ordinance from this
Correct.
table. Yeah.
But yeah, because the downzoning prohibition from the state, we can't go that route. We can't regulate.
We can't
500.
go that route in this. We could still push it forward in the UDO if we wanted to, right?
That's correct.
So it can still be, it can't be done in the name of public safety policing.
Correct. Yes, since the UDO,
The UDO is separate. This is a courtesy they're doing for us right now. This doesn't have to come to us at all. This is done through the municipal police policy, I believe is what it's called.
the UDO, as you know, is exempted from the downzoning prohibition.
That's
So
why,
anything adopted in that ordinance, which would most likely include floodplain, would be exempted upon adoption.
we're going to reinforce, we hope this is enough to put this in place, right? The police approach.
That's the
But
recommendation.
if not, we're going to back it up with UDO anyway, right? To keep them on
That's
the
the
other
recommend-
side of the moratorium though.
Correct. That's the recommendation from the attorney and staff. Yeah.
But we, as all being part of the UDO, could go above and beyond this if we could at least bring that up in the conversation.
That's correct. So since the UDO is exempt, you could do a downzoning land use regulation, which could include more extensive floodplain management
Yeah,
regulations.
that's where I'm going with. As an example, just pack all this just the way it is, but maybe we put something in the 500. You don't need to quote me on this, but I think it was like 13% of the town was in the special flood, right? Something done, and I shouldn't have said a number. You're gonna have to have an exact number. But there was a huge portion in the 500. I think it was equal to the special flood hazard area. It
It's a
was
large number.
Yeah, it was a large number. So if you look at all of our, the floodway is it always floods right here on the banks of the creek, the 100-year and then the 500. So we're not going out to what I believe is more than half of our total flood. To say nothing for the Helene stuff. So you may want to think about what we bring up to the UDO. And I still have other questions, but I know Michael's looking at it because I just wanted you guys to hear the number. It's a big number. So, and I know it's not part of what they're doing under the town council's approach right now. Oh, I'm sorry. Oh, no, I was on.
So here we go. So,
Thank you.
so for floodplains in Mills River, and again, we've got the Mills River, Boylston Creek, the French Broad River, and McDowell Creek. So over 2,000 acres, 3.23 square miles, 15% of the town's jurisdiction is in a floodplain of some type. Again, 100-year, not 500.
Special.
Correct.
The SF, HA.
Yes. Now floodways, the narrower part of that
Right.
is 772 acres, 1.21 square miles, so 5.5%.
And do you have the acreage for the 500?
No.
Okay.
Mm-mm.
It's big. What's that? Yeah. Yeah.
But yeah, the number to go off of is 15% of
Yes.
the town's jurisdiction is in a floodplain.
Right. It's a big portion of it.
How will it work if, what is the interplay here between this and a subsequent ordinance that's included as part of the UDO? Assuming it does get addressed in the UDO and maybe it goes broader, maybe it goes the downzoning route, would that end up superseding this, or does this, what is the thought process in how those two things will eventually interplay if they do end up existing in both places?
Enforceability.
Yeah.
The idea would to not have them in tandem. It would basically be to incorporate what the town desires in the UDO, adopt that and run with that. again, this is, you know, to fill the gap in a way.
So-
The moratorium ends in 4 weeks.
Right, so this is, you know, again, and the- so, and I know that there's been a lot of work to get this to this point, but, so this is, or if something happened and it didn't end up being addressed in the UDO, you know, this will be in place. But the UDO, if to the extent it does address it, it would end up sort of assuming this.
Yeah, well, they don't it doesn't supersede it because
Yeah.
it's a separate type of ordinance.
Yeah.
Basically, and I'm getting ahead of, you know, the elected body here, the governing board, but my guess is that if the UDO included floodplain management regulations comprehensively, and if those were adopted by council, council would then come back and repeal this because it would overlap.
Right, because that ultimately, again, just kind of like long-term vision, the UDO is meant to eliminate any potential conflict within our ordinances so that we don't have kind of competing ordinances. So that would be sort of down the road,
Correct.
what we think may happen with this, but until then, this would have something, this is intended to kind of have something in.
Correct. And again, this isn't in the zoning or land use section. This will be its own, I believe it's Title 14, or maybe it's 16. But this will be its own section living by itself in the town's code of ordinances. So again, because they're totally separate, it would be most likely be another action of council to come back, do away with this, because whatever's in the UDO will replace this.
Got it.
And again, through the UDO, because we're exempt from the down zoning, we most likely will create a floodplain overlay district because, again, we have that authority and the regulations will be tied to that, and that district will be tied to the FEMA maps.
And the current target date for the UDO is May.
Yeah, you should see a full draft before then. Obviously, the statutory deadline, July 1.
Right, so if
26.
nothing else, we're attempting a gap fill in hopes of deterring it until it can be codified under hopefully the UDO.
I think it's really helpful, particularly if there's anyone in the public listening to kind
Hopefully
of,
we don't duplicate, or hopefully we just duplicate it
Yeah.
into the UDO. Hopefully there's not. you know,
Right.
Just copy and paste it.
okay. Did you have more questions?
Yeah, I have a
Fine.
few. I mean, the non-conversion agreement's a big one to me. Because I see a loophole in it. I just want to feel good that somehow that's going to be. So, I'm familiar with them, but not for this purpose. So the non-conversion agreement is public notice at the Registry of Deeds that the max fill has been applied for and filled. It runs with the land. So that 5%, just, you have 20 acres and they fill in 5%. And just to clarify, that 5% is of the special flood hazard area, not the whole parcel.
That's what I was just
Okay,
going to say.
so just to clarify that for everybody here, it's only the flood. So I'm gonna say there's 20 acres of actual special flood hazard area. Okay, just for simple math here. So there's 20 acres there and they fill 5%, which is an acre. The conversion agreement has to be recorded in a way, that attorney has to draft it in a way where any future survey done pulls that up to any future parcel within that 20 acres. Specifically, you have the 20 acres, you fill an acre, 5%, and you survey off that acre. Now I have 19 acres that has no fill in it, has none. It's zero. I can put 5% of that 19 acres filled. So the non-conversion agreement fixes that as long as it's recorded the wording has to be, it has to apply to any future subdivision of the original parcel number. And as long as just to make sure that the attorney puts that in there, because the intent is not a workaround that I just described. It is not to take an acre out of that 20 acre, fill it, and then survey off that acre and then fill in 5% of the 19 and do that until you're left with the spot this big that's not filled. And now I can develop on the whole 19.5 acres. So I just hope that somebody with some more experience than me writes that non-conversion agreement. Because I hate to see a potential loophole there. The sod farm, But what was the fill how for them? Because they replenish the topsoil.
I wouldn't consider that fill because again, if it's not changing the elevation or the topography of the land, it's not considered a fill activity. So if you're doing soil amendments, if you're turning dirt, obviously, you know, if I go out there with a ruler and one day it's the grass and one day they've tilled it,
Yeah.
there's gonna be a couple inches difference. But generally, the average elevation of that land and topo.
Oh, it stays roughly the same. If
Yes.
you see them harvested, it's removing
Mhm.
below, but then they have to bring it back. So I just want to make sure there's not some inadvertent, hey, we just screwed the sod farm.
No, and again, the focus is, you know, if there's a line of dump trucks coming into a property with fill dirt and depositing that.
Oh, I
that's-
get the intention.
Yes,
Yeah,
that-
not the
that would
intent, I'm
be-
sorry. And the ag buildings in the special flood, help me with that. I'm not trying to steer you here. I don't know the answer to this. Putting up agricultural, bona fide agricultural buildings. On page, what do we have? 11 and 15 are my notes. So on page 11, item number 2 under Article 3, Section B, item 2. Under prohibited except, there's your first mention of that. And I just want to make sure I understand what can, because this is going to change the ag exemption to ag exempt except.
No, because this is not a zoning ordinance.
There's where I miss it. So when we go to UDO, we're going to have that problem though. It's going to be ag exempt except in the UDO.
That will have to be addressed.
Okay. Okay, that's where I was going. Okay, so that I keep forgetting this isn't up under the safety, the police, municipal police. This is not encroaching on the ag exempt. The town,
Not
currently
to
have.
my knowledge. And again, the way it reads on those 2 pages,
those, you know which two run?
yes,
Okay.
is again, so an allowed, page 11 states that bona fide farm or ag land uses and structures, and it goes on to say, as defined and regulated in the rest of the ordinance is an allowed development type.
Then permit
And then
exception.
15 goes into
Outside.
the permit exemptions, and it basically says no permit is required for a bona fide farm or ag structure as long as it's outside the floodway.
Okay.
Now, you're right, you know, currently, if a farmer wanted to put a pole barn in the floodway, well, again, there's a moratorium right now. But before the moratorium was in place, they could do that. Now, I think in conversation with our agricultural community, most of them don't because they also recognize the hazard of
Oh,
doing
sure,
so. But you are correct. So this would limit it to basically saying any ag structure development must be outside the floodway.
Okay. So for now, this is not the ag exempt except is going to come into the conversation for the UDO part of this because it's an ordinance.
That's correct. And there'd be, you know, not to get into the UDO, but there would be other changes too, like actually having a statutory consistent definition of what ag is.
Bona fide, yeah.
Because in the statutes, it's very clear that it's, you know, farming and ag that occurs on that property. And if it's not related to that farming, like if I run a car repair shop, but I happen to be on a farm, well, guess what? That's not protected
Right.
or exempt. Those are the types of clarifications we'd be looking to make in the UDO.
I think we're overdue for that conversation. Totally. I know that's a little bit of a you know, a tangent I'm going off on here, but I think we're way overdue for that conversation. So I'm happy to have it, but you're right. It's not here. This is under the police, the municipal policing. Okay. Thank you. Non-conversion agreement is something that's attached to a deed. That needs to come from an attorney. The law actually says that the attorney, only an attorney can draft that. So Michael, I believe, you know, it's not the intent of 99% of the people out here, but it's those 1% that are going to come along and screw us over in the future that these questions are asked for. I would love to see the non-conversion agreement protect. That's right. So I would like to see an attorney that has some experience with this, that makes sure that it's to any future parcels that are up, that are currently in that parcel and then name that parcel.
Or subdivided into.
Right, so a title search, and, you know, a surveyor is going to find that in the future. Because what I don't want to happen is some of this half, the 5% stayed over on this half, and this new owner from out of state or whatever, it doesn't matter where they're from, this new owner comes along and brings a permit over, and they're gonna get approved for it. If we don't have that safety, I'm sorry, the clause in there in the non-conversion agreement.
Where's that clause?
In the Register of Deeds, it is literally runs with this property in perpetuity for forever. It just has to be worded correctly so that a surveyor sees it, says, oh,
I don't think it hurts though, and your point's well taken, to include that guidance in here, because it would really just be half of a sentence.
it is,
Um,
it is, but it
so I-
changes everything.
Correct. It would be, and I'm looking at the section right now, it is actually right at the end of the ordinance at the top of page 24.
Yep.
And it states non-conversion agreement required for fill. Any placement of fill in the special flood hazard area requires a non-conversion agreement with the town to be recorded with the Register of Deeds, which shall run with the land in perpetuity and bind future property owners. And I could just say comma, and all subdivided land from the original
That
parcel.
originated from the original, from the parcel. Yeah. Yeah, that'd be great. I appreciate that. I know that's a little in the weeds, but I could just see a workaround there.
Now, again, as you said, it will all come down to the legal agreement, but you know, if I'm not here, that at least gives direction to staff
You going
of
somewhere,
what
man?
to do.
Why are you saying that stuff?
No,
No, it's not funny.
well, no,
No.
well, it's just like the UDO, you know, once it's adopted, you don't want it to sit on the shelf. And, you know, we just have to think of, you know, in the future that, you know, comments have been made that, you know, luckily we have a great staff. But we want to make sure we're providing the correct guidance for the future of the town as well.
Yeah, that's always how I'm looking at it. Thank you.
Yep.
That was great. Did you say you had some responses to the questions that were sent by email?
I did. Yeah, so the planning board received Mr. Burton's report and some of his comments, so I'd like to go through those. So under number 1A, he says, would a floodplain development permit be required? And basically, this is for a specific situation where someone owns a single family home that encroaches into the floodplain by about 8 feet. And so basically, would a permit be required if they wanted to add an addition into the floodplain area? So my answer to 1A is yes, a permit would be required, but it wouldn't be issued because we're not going to allow a residence to be in the floodplain area. Now, if it exists there, it exists there, but we're not going to allow an expansion of more hazards into the hazard area. For B, he states under the same situation, would an addition to a structure be described as development activity? And you can actually look up the definition of development activity, and it states structure including expansion, so that the answer is yes. As written for 1C, would the ordinance allow an addition on the opposite side of the house? So basically, I responded that one, again, a permit would not be issued to put an addition to expand a single family residence into the floodplain area. The only option for that homeowner would be to put the addition on the other side of the home outside of the floodplain hazard area. And honestly, that would be how they would have to comply in that situation. For number 2, the same situation, a single family home encroaches into the floodplain by 8 feet, but it's burned down. Can it be rebuilt? And basically, yes, it could, because the foundation's already there. So what Mr. Burton's getting into is substantial damage and substantial improvement, which is something council chose not to include, because again, it gets more in line with the FEMA NFIP requirements. Substantial damage means traditionally, if the home's damaged 50% or more, you can't rebuild it. Substantial improvement means if I improve my home's value by, let's say, putting an addition by 50% or more, I have to meet all the new criteria, which again, in the traditional ordinance means elevating, flood proofing, having flood openings in your foundation to allow the floodwaters to go through so your house isn't, blown out, basically. Those are items council's chosen not to include in the ordinance. So those types of things would not be allowed. 3, does a registered landscape architect qualify as a licensed professional? They do. And actually we see site plans from landscape architects. I won't say frequently, but regularly. Because again, they're a professional that can put together something to scale with a north arrow, correctly oriented and all that. So they would qualify as a professional. Under his question 4, he talks about elevation and reference level and FEMA's elevation certificates. And basically said, while the town has no need for such items because we're not doing NFIP, he provided some diagrams that might be helpful. So the main purpose in this ordinance for elevation analysis is to track fill. Because again, we're not requiring structures to be elevated. If the applicant wants to, put a structure on 3-foot posts, that's up to them. But we are only regulating the amount and the elevation of the fill. Again, normally can't go above base flood elevation. Through a variance, can only go 2 feet above BFE. So again, I wrote that staff want to be able to track elevation via fill, hence the requirements. Elevation requirements for structures are not included, hence no elevation certificates. Again, happy to reference the diagrams, in applications and to provide them. And we do have a lot of FEMA guidance regarding floodplains that we can still share, but it just wouldn't be in the ordinance itself. Number 5 stated who designates the floodplain administrator, and actually this language is included in Article 4, Section A. I'll scroll through it real quick. It actually states the town planning director or his designee, hereinafter referred to as the floodplain administrator, is hereby appointed to administer and implement the provisions of this hazard prevention ordinance. So that's all in there. And lastly, I believe was number 6, about the definition of start of construction and substantial improvement. What I wrote down is that, again, substantial improvement is not considered in the ordinance. So again, that wouldn't be relevant for the way this is written. We do have a definition for start of construction. And again, it's more for a structure. So it's when you start erecting something on the property. There is also a definition for development, which, is broader and includes, excavating, grading, filling land. So we still have regulatory capacity there that if we don't have to wait for someone to start building something to do enforcement. If someone's out there putting dump truck loads of fill on a property that we know has not been permitted, we can go after that because of the definition of development in the ordinance, and any development has to have a floodplain permit, and it's only for those 6 types that are allowed. I think that was all he emailed.
Very helpful. Any other questions or discussion? We have a quorum still, if we wanted to make a motion tonight to recommend the adoption of the ordinance.
I know it was brought to us as a courtesy. Are you asking for a vote from us?
I am, because we feel it's prudent just to go through the normal process. So, in your staff report, staff's recommending, also the planning board recommend approval, and there's also a draft statement of consistency for consideration as well.
Well, I think this looks like it's an issue that's come up in discussion in the planning board meetings since I've been on the board, and knowing that we may adopt or change something based on what happens in the future, I don't think should prevent us from acting on this today. It's really great to see how much work and thought was put into doing something and on that basis of kind of public safety. I mean, at the very least, I think that's something that we all experienced in real life in the last year. So, you know, I open it up to the board to kind of get their views on, or if anyone wants to jump in on making a motion. Have any other comments or thoughts?
I mean, I'll make a motion that we adopt this as consistent with the state.
I will second that.
Thank you, Mike. Thank you, Jenny. All right. So do we have do we need to read this before, or can we just make the motion? It's been a minute. Okay, great. Then I will ask for all in favor of adopting the statement of consistency to recommend the adoption of the floodplain hazard prevention ordinance. I'll say aye in favor.
Aye.
Hearing no nays.
For the record, that would be Dan.
Okay, so that's, do we need to read any of this into the record? Excellent. Well, that's great. I think that's a big
Yeah,
step
no
forward.
joke.
Yeah.
Yeah, dude, this is awesome.
When you say spring and summer, it wasn't 2 days after that.
Yeah. That's a,
Hopefully we could copy and paste a lot.
Mm-hmm. Or expanded to the 500 year.
Can we expand the definition, please?
To Mike Cole will be, be our police.
for his
Save that
designee.
for another day.
Excellent. Okay, good. Moving on then, are we going to be delighted with some additional education tonight?
Yeah, so we do have a very short training video going over the types of land use decisions tonight. I will be turning the video off for the public. Just a reminder, this is a copyrighted School of Government material. So this is not something we can broadcast out to the public. So we will be turning the screen and the videos off for about 15 minutes while the board reviews that video, but we'll come back before adjournment. And we'll take a few minutes to get that set up on the screens. So
Thank
thanks
you.
for watching that. Didn't know if there were any questions. Again, it was just a quick review of the three types of land use decisions: administrative, quasi judicial, and legislative. The one thing I did just want to note, we've talked about this before, but technically in Mills River, subdivision approvals, although they come before this board, are technically administrative, because as we've seen, that's where the board has limited discretion in what can be applied. And it's really strictly, does the development meet the standards of the ordinance? That was the only item I wanted to highlight.
Think those are helpful. Give a little clarity, so thank you for that. Do we have any other business or comments for this evening? Billy? Excellent. Mike has seconded that. All in favor of adjourning tonight's meeting, say aye.
Aye.
Anyone not in favor? Hearing none? Thank you.